Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal updates from 21st March to 26th March 2022. In first important news, the Supreme Court has held that an insurance policy containing a condition which bars a claim after a specified time limit is void under Section 28 of the Indian Contracts Act. In the case of the Oriental Insurance Company versus Sanjesh, the Supreme Court has held that an insurance policy condition which bars the filing of claim after specified time period is contrary to Section 28 of the Indian Contract Act. Such a policy condition would therefore be void. It is important to note that Section 28 of the Indian Contract Act provides for agreements in restraint of legal proceedings as void. The section provides that any condition or any agreement which extinguishes the right of a party to institute legal proceedings on the expiry of the specified time period would be void. In second important news, the Supreme Court has held that mere breach of contract does not give rise to criminal prosecution for cheating. In the case of Vijay Kumar Ghai versus State of West Bengal, the Supreme Court has held that a mere breach of contract cannot give rise to the criminal prosecution for the offence of cheating. The court has observed that a mere breach of contract is not in itself a criminal offence and it only gives rise to the civil liability of damages. Even in a case where allegations are made in regard to failure on the part of the accused to keep his promise, in the absence of a culpable intention at the time of making promise being absent, no offence under Section 420 of IPC can be said to have been made out. In third important news, the Supreme Court has held that a High Court cannot direct regularization of temporary employees by creating supernumerary posts. In the case of State of Gujarat versus R.J. Pathan, the Supreme Court has held that a High Court under Article 226 of the Indian Constitution cannot direct regularization of temporary employees by creating supernumerary posts. The court has observed that a High Court has observed that even while absorbing or regularizing the services of the respondents, the state government may create supernumerary posts. Such a direction to create these posts is unsustainable and wholly without any jurisdiction. No such direction can be issued by a High Court for absorption or regularization of the employees who were appointed in a temporary unit which was created for a particular project, and that too by creating supernumerary posts. Lastly, the Supreme Court has held that states can levy tax on lotteries run by other states. In the case of State of Karnataka versus State of Meghalaya, the Supreme Court has held that state legislatures have the competence to levy tax on lotteries organized by other states. In this important case, the court was actually dealing with the interpretation of some entries of List 1 and List 2, in which the court has held that the state legislatures are denuded of their powers under entry 34 of List 2 only to the extent of lotteries organized by the Government of India or Government of a state in terms of entry 40 of List 1. In all other cases where the activities are of nature of betting and gambling, they would come within the scope of entry 34 of List 2, and in that cases, entry 40 of List 1 will not affect the power of the state legislature to make a law. This brings us to the end of our video. We have a short announcement that Jurisedge Academy has already launched its All India LLM Short Life course. So if you are interested, you can check out the details of this course from the link given in the description box. If you like this video, please like and share and subscribe to our YouTube channel.